My Lord, Respondent's Notice Ground 2. To the extent that the propositions advanced under it constitute additions, we contend that the judge's conclusion was correct for the reasons we've set out under Respondent's Notice Ground 2 and developed at paragraph 49 to 49.4 of our skeleton argument. On this alternative approach, there is no need for recourse to any concept of targeting, and it is simply contended that the concept of applied directly connotes a direct, immediate, or proximate nexus between a given action on the one hand and its impact on the value of the investment on the other. And that is, we submit, very close, in fact, to the approach taken by the judge at paragraph 111 of his judgment, and is really just another way of expressing the closeness of connection, which we say is sufficient to meet the test of applied directly. And as I've already submitted, the binding action in issue in this case was, we say, in context, only sensibly interpreted as applied directly to the value of RAKIA's shareholding as invested in the project in that immediate, proximate and inevitable manner, for each of the reasons that I went through this morning. If one asks the simple question, how should the treaty be understood in good faith, having regard to the ordinary meaning of its terms, in their context, in light of the treaty's object and purpose, and frames it perhaps more precisely for the present context, it could be posed as follows. Is binding action which inevitably and immediately had a negative impact on the value of this particular shareholding in this particular company, action which was applied directly to that shareholding? And we respectfully submit the answer must be yes, just as it would be in the investment by loan and seizure of cash scenario. And the basic point in this regard is really the one that we make at paragraph 49.2 of our skeleton argument, which I'll adjust slightly to avoid or reduce the risk of potential quibble in terms of the precision of its language. In the context of a treaty regime, one of the characteristic features of which is its embrace of claims for loss by shareholders, for loss in value of shares, adverse action taken against the business of a project company which causes precisely such loss is, we would say, must be action applied directly to shares in that company qua investment. My Lord, that was all I wanted to say about Respondent's Notice Ground 2. I was going to end my submissions, as I said at the outset, going through each of the provisions of Article 31 and 32 to say why they supported us, but I think I couldn't resist the urge to get there earlier on, so I think I've made those points, and I'd be repeating myself if I did. So unless I can attempt to assist further, that's how we put the judge was right for the reasons he gave and Respondent's Notice Ground 2, and I'll pass over to Mr. Juratovic to deal with Respondent's Notice Ground 1 and 3.
Yes, thank you very much.
Thank you, Mark.
My Lords, Respondent's Notice Ground 1 is that RAKIA's investment was not limited over time to the shares, the cash and the pledge as found by the judge. It also included the contract known as the bauxite supply agreement. Whether that is correct is a question of interpretation of the definition of investment in Article 1.1 of the treaty, and then the application of that interpretation to the particular facts of this case. It is another reason to uphold the judge's decision because it is undisputed that GOM 44 was applied directly to the BSA and satisfied all the other requirements of the definition of a measure. And
I'm
our
not
submission-
saying if you have an investment in assets, it must be in all the assets, mustn't it, of ANRAK? It can't be in just one asset.
This is alternative, my lord, in the sense that the judge didn't find it. It's not alternative in the sense that it's alternative to the shareholding. Our case on Respondent's Notice Ground 1 is that RAKIA's investment was also the BSA.
No, I understand it's alternative, but you're trying to understand what it is. And you can't be saying that they invested in the contract, but not, for example, in the plant.
Well, I'll come on to the terms of the contract, which will assist your lordship with that question, because it covers, in broad terms, the building of the plant. And I do say that the plant, for example, could constitute real property for the purposes of the definition of investment in Article 1. It's not the basis of this ground, which is focused on the contract.
You
Analytically,
accept that
yes.
none of these things are your assets.
They are not our assets in the sense that they do not belong to us under Indian private law, by which they're governed for the purposes of Indian law. But that's a different question, my lord, as to whether they can constitute investments of an investor for the purposes of Article 1 of the treaty, governed by international law under the Vienna Convention principles.
If it's an investment, why isn't your investment just simply you're investing in the enterprise, the business of ANRAK?
The answer to that, my lord, is because we accept on appeal that our investment must constitute assets. And in determining whether any of those assets are investments, one may look, following the holistic approach that's been debated, at the broader context to which my lord refers. But that doesn't mean that we're saying that that broader context, the project, the business, is itself a protected investment. It is still an asset that must be a protected investment.
Is it only this contract? Because ANRAK had other contracts. It had contracts of employment. It had a contract with maybe the cleaning company who came in and cleaned the premises. Are all of those contracts assets within the definition of investment?
They are not, my lord. We are making our case on the BSA, not on all of those other things.
Why is that different from all the other contracts which it had?
There may be other contracts that ANRAK had, but they would need to have the quality of an investment in order to come within the definition of investment in the treaty. And we say that the reason the BSA is different is because of the particular characteristics that attach to it, which will be the first part of my submissions.
What about cash in the hands of the company? Borrowed loads of money from banks, as we know, and it's then sitting on a pile of cash which it's going to employ in the business, and no doubt the cash is there for the purposes of the business. Would that be included?
It could be, my lord. It could be if, for example, an equity investment was made, the shares were pledged to gain money for the investment company, here ANRAK. That money was kept in ANRAK's account, the money coming from the loan from the banks based on the pledge. If that money was then taken, we would say in that case that that money would be capable of constituting an asset for the purposes of the definition, yes.
But does that depend on the existence of the pledge, that argument?
As I put that hypothetical, the pledge would be part of it. If it was cash in the ordinary course of business, then I would not say that that's an investment. I accept that. But if, to use Mr. Wordsworth's example, which he sought to use as an analogy against us of liquid mercury, and combining that with my Lord's focus on the change in form provision, earlier today, it's entirely possible that what the asset protected by Article 1.1 is could change over time, and it could follow that money if that money constituted an investment that then changed form. But the question would always need to be asked, is it an investment that satisfies the Article 1.1 definition? And the answer for different contracts or cash in different scenarios might or might not, depending on the facts. So we don't say that all contracts or all assets of ANRAK or in the project generally constitute investments. We say the BSA was an investment that was invested by RAKIA.
Is your investment the BSA or 12% of the value of the BSA, or whatever the right percentage is for your shareholding?
It would be the BSA.
All of it.
And on a question of quantum of compensation, the fact that there was a 12% shareholding in the company that was party to the BSA would be relevant to the determination of quantum of compensation.
Okay.
The only way for me to make good on this proposition is by looking closely at the facts, and I'll do that first. I'll then take your lordships to the law, but in two parts. First, the general principles on the scope of investment treaties and their relevant differences from other legal frameworks. And then the second part, to distinguish, to look at India's attempt to distinguish the cases that we rely on. And the key point there, it goes to the point that's just being put to me by your lordships, is that India accepts that a contract to which a company is party can be an investment made by a shareholder in that company. India accepts that, so the disagreement before this court is not about a point of principle on the corporate veil. It's India's argument that the critical factor is majority ownership or control. That's India's case, whereas we say that that is not a principal distinction under this treaty. So the key point of disagreement is not the Indian...
I hadn't detected them accepting that, but you might be right. I hadn't detected that they'd accepted anything like as broad a proposition as that, but perhaps you're right.
Well, they're certainly not saying that the cases in which that was found are wrong.
Can you give us the transcript reference to where they accepted it?
I don't have it. I'll come back to you, my lord, on that. But the point that I seek to develop is that in the cases where there has been that look-through, it is not the majority or control that is the determining factor. And then the third part, very briefly, will be to apply the terms of the treaty to this case.
So I'm really struggling with the basics here, because we know that your investment was the 42.5 million. An investment, we understand the concept, is a capital injection into an enterprise. And we know from the terms of the treaty that we can have an initial capital investment, and then it matters not that that is subsequently change of form. And we know that the change of form of that 42.5 million was into shares. So we know that you invested 42.5. We know that what you got in return for it was shares. So where is the scope for saying that you also have, your investment is also a contract in which you have no interest?
My lord, 2 points in response to that. The first is, if we're right on the premise of your lordship's question, and if what Mr. Ottey said before the lunch and adjournment is correct,
It's not indisputed.
then we don't need, on applied directly, I mean, if he's right about that, then we don't need this ground, of course. But on the second part of your Lordship's question, we accept that we're not party to the contract or that we don't own it as an asset. But with respect, that's not the relevant question under the treaty. The question is whether it constitutes something invested by, and the fact that RAKIA already owned the shares doesn't preclude it from having an addition.
So you say that the reference to asset, an investment being an asset, doesn't mean an asset of the investor.
It doesn't need to be owned by the investor. That's our case.
But it has to be invested by the investor.
Yes.
It has to be an asset which is invested by the investor. So there's the change of form provision, which you referred to, and one can see how that takes the money which is invested and turns it into shares, for example. But how can you say that the money was ever turned into the contract?
I don't say, my lord, that the contract is a change in form of the money. I don't say that through the shares.
So how was the contract something that the investor, how was that an asset which was invested by the investor?
That turns, my lord, on the terms of the contract and the context in which it was agreed. And in our submission, the answer to that question is because the factual link between RAKIA as the investor and the contract was so great, given the cornerstone of the investment being the supply of bauxite, that link was so tight that it constituted an investment for the purposes of the treaty, even though it wasn't owned for Indian law purposes by RAKIA. That's the submission, and I accept that the only way I can make good on that is through the facts, a number of which, my lords, you have seen in reference to the judgment, and Mr. Otti took you to those paragraphs of the judgment. But what I propose to do is to take you to the underlying documents so far as they concern this specific ground. And the first of those is the MOU at Supplementary Bundle tab 5. It's at page...
Is this for things which aren't in the judgment?
It is to show the context of those that are not in the judgment and to show you those that are not in the judgment. It's 187 of the Supplementary Bundle. There one sees the recitals to which Mr. Otti took you, and then coming down to clause 2, which is on page 189. This is GORAC's undertaking that with RAKIA it will incorporate an Indian registered limited company, and that of course became ANRAK. Mr. Otti then showed you clause 3, which is on page 190, and I would just add the last sentence, which refers to APMDC and the government of Andhra Pradesh shall not sell or export bauxite from the Jerala deposit to any other party during the period of operation of the said aluminium company. And then at 192, we see clause 11. India's refrain has been that the MOU contemplated that RAKIA's investment would be in the form of shares in the project company. And that is correct, but in our respectful submission, incomplete, arising from clause 11, which provides in the first line for a detailed collaboration agreement, between APMDC as the public sector entity producing the bauxite and the company to be established by RAKIA to use the bauxite, so ANRAK, and that agreement was evidently what became the BSA. The shareholders' agreement is at tab 6. If I could ask your lordships to go to page 194. The nexus with the MOU is expressed in the first recital, where there's the reference to the Memorandum of Understanding. And then, perhaps of more interest to your lordships, on page 198.
Is this somehow said to be relevant to the interpretation of the treaty?
This is relevant as the factual basis on which we say that RAKIA had an investment that included the contract.
But the only way you get there is through the words of the treaty.
Yes, and I accept that these don't help in interpreting the treaty, but it is to these facts that the court is called to apply the treaty. The point arising from 5.3 is that RAKIA had a defined governance role because quorum for the board of directors requires a minimum of one director that it appointed. And then on 199, at 6.2, the court will see a form of negative control over a series of reserved matters. And those include, in 6.2.2, the expansion of the company's objectives beyond the execution of the project.
But this is just between the shareholders. I don't understand this point at all, with respect. This is just an agreement between the shareholders in the company. It's not even to do with the relationship between ANRAK and APMDC. It's just saying this is how the shareholders agreed to arrange their affairs. So how can that possibly assist in construing the agreement, or even or telling one what counts as an investment under the agreement?
It doesn't assist with that interpretive question, my lord. It does assist, we say, with the question of application of the treaty as correctly construed to these facts, which include that RAKIA was able to ensure that the project company in which it was investing could not expand its purposes beyond this particular project. And that's relevant because it's said that an issue of control is a distinguishing feature between the cases where there was a look-through and our case. The next document, my lords, is at 205 of the same bundle. That is GOM 222. Where paragraph 1 refers to the MOU, and then it refers to the sale of bauxite by APMDC to an aluminium company to be incorporated by the government of Iraq. And at 209, paragraph 7 records that the government directed APMDC to enter into the bauxite supply agreements. The next document is at page 211. That's GOM 289. The first paragraph describes the MOU, the second GOM 222, which we've just looked at, and then paragraph 6 approves the BSA and authorises APMDC to enter into it with ANRAK. We then come, my lords, to page 213, where we find the bauxite supply agreement. India identified yesterday that APMDC is the seller and ANRAK is the other purchaser. Recital A on page 214 describes ANRAK as established in Andhra Pradesh by the government of Ras Al Khaimah through RAKIA, and it notes that it proposes to build a refinery and smelter, and then it records that to this extent they have entered into an MOU with the government of Andhra Pradesh. Recital B of the contract begins by recalling that the seller is a government undertaking which has a mining lease for extraction of bauxite from Kerala. And then on the last 6 lines of 214, the government of Andhra Pradesh and the government of RAK entered into the MOU, in terms of which the government of Andhra Pradesh agreed to mine and supply bauxite by APMDC from and out of the Kerala mines. On 215 we see the operative terms of the BSA being introduced. And on page 220, in clause 2.2, to which Mr. Otti referred, we see the long-term character, and it provides that the BSA shall remain in force for the lifetime of the plant, or until the exhaustion of the Kerala bauxite reserves, whichever is the earlier. Clause 3 is relevant, including because my Lord Justice Males remarked yesterday on the significance of paragraph 3 of the MOU, and here are the same terms in clause 3 of the BSA. Page 223, we find clause 7b requiring ANRAK to utilise all the bauxite it purchases from the seller at its refinery and smelter in Andhra Pradesh. And then on 236, is clause 18, where on the back of the promise of reliable and exclusive supply of bauxite from the Kerala mines, ANRAK took on the cost of building a refinery and smelter. That's the first paragraph. And conscious of what fell from my Lord Justice Males this morning on infrastructure, in the second and third paragraph, drafts, also took on the associated infrastructure costs, such as roads, water supply, and its own power generation facility. So, my lords, although this is called a bauxite supply agreement, in substance, it was much more than a simple contract for the sale and purchase of bauxite. It was, in our submission, the contractual implementation of an investment project in which the government of Andhra Pradesh, through APMDC, was to supply all of the bauxite at Kerala to a company established by RAKIA, and that company, ANRAK, was to use all of that bauxite only in a refinery and smelter that, together with all the associated infrastructure, it was
Does any of
committing...
this go to whether it's an asset of RAKIA?
My lord, with respect, the error in the premise of your question is that it doesn't need to be an asset of RAKIA. It needs to be something that is invested by RAKIA, but that is a different question from whether RAKIA is a part
why do its terms matter then?
Its terms matter because this is a contract through which ANRAK, as capitalised by RAKIA, or including by RAKIA, is committing to do these things, including building a smelter and building infrastructure.
Yes, well, we know that. We've seen that.
You've seen that in the general sense of the project. This is the contractual obligation to do so. And the submission, my lord, is that this contract constitutes an investment because of the kinds of obligations that it contains.
So you say it's not relevant, that clause 31 isn't relevant?
We don't, my lord, say that RAKIA is entitled to enforce rights under this contract. What we say is that the contract as a whole constitutes an investment made by it, and on that basis we say that clause 31 doesn't prevent the submission that we're making, just as the existence of a dispute resolution clause in the contract is relevant to the resolution of disputes concerning the rights and obligations within the contract, but not to whether there's a breach of the investment treaty arising from the loss of the contract as an investment. That's our submission.
Right, well, those seem to be the facts. Where do we go now?
My lord, that then takes us to the law. The first part of our submissions on the law is general principles on the scope of protection under investment treaties and the distinction between that and other legal frameworks. And we have three propositions building on the framework introduced by Mr. Otti. The first is that there's no barrier in principle to the rights of a company in which an investor holds shares being treated as part of that investor's investment, and whether, this is the second proposition, whether a treaty does so depends on the correct interpretation of that treaty as the lex specialis, and then the application of that treaty to the particular facts. The third proposition is that rules and cases relating to the corporate personality and privity of contract in the different contexts of domestic private law and diplomatic protection under custom provide no material assistance. And we say those three propositions are supported by the cases we have cited at paragraphs 15 to 20 of our skeleton argument. And I'll go through four cases. The first of which you have seen some of already, that's Korea and Diani. It's in your volume 3. It's tab 44. If I could ask, it starts at page 903. In Diani, the argument advanced by the state was that the shareholder claimants had no standing to bring a claim because they were complaining about interference with rights under a contract to which they were not a party, and the fact that they were shareholders in the contractual party was said not to be sufficient. That argument failed. And the basic facts and issues Mr. Wordsworth referred you to, if we could start at page 906. The dispute arose out of the failed acquisition of Daewoo Electronics by a company called D&A Holding. Daewoo was incorporated in Korea, D&A in Singapore. The key agreement in issue was a share purchase agreement entered into by D&A and Daewoo. At paragraph 16 on page 908, the claimants in the investment arbitration against Korea were the members of the Diani family. They were Iranian nationals and shareholders in the Singaporean company, D&A. The arbitration was under the investment treaty between Iran and Korea. And so this is not a case, picking up on what fell from my Lord Justice Miles, where the indirectness arose because of the relevant company being incorporated in the host state of the investment. The Dianis alleged that the majority shareholder in Daewoo, Camco, had caused this transaction to fail and that Camco's conduct was attributable to Korea. Korea objected to the tribunal's jurisdiction. The key questions on the Section 67 challenge, for our purposes, were identified on pages 910 and 911. As questions 1 and 4. They're at the top of 911. The definition of investment and investors in the Iran-Korea investment treaty was comparable to ours. And then at page 914, Mr. Justice Butcher rightly described in paragraph 37 the definition of investment as a very wide one, not limited to the enumerated categories of assets. And at 42, on page 915, he added that read in context, neither the term asset nor property is confined to rights in rem as opposed to rights in persona. Then the key part of the judgment for our purposes is at page 920. There's the treatment of question 4 starting at paragraph 68. The judge indicates at 69 that the focus is on the claim being made by the Dayanis as the Iranian nationals, not by DNA, which was the Singaporean company in which they held shares and which was the party to the SPA. The issue at 70 and following was whether the investment represented by the SPA was invested by the Dayanis. Paragraph 70 summarises Korea's case on that issue. It's not dissimilar to the position taken by India here. The judge then made a series of points rejecting Korea's objections as summarised at paragraph 70. And then on page 921, at paragraph 72, there is a rejection of equating the treaty requirement of an asset invested by an investor with ownership in terms of domestic law. He says an analysis of this issue must commence with the terms of the bit. The terms of the bit, whether Article 1 or Article 12, do not include any express requirement that the investor own or have a direct legal interest in the property or asset which constitutes the investment. Nor do I consider that any such limitation, which could have been expressed if agreed between the contracting states, can be read into the treaty wording. That would appear to me to be a rewriting of the treaty. And he then cited a series of awards showing that claims by investors in respect of indirect investments had been held to be jurisdictionally well-founded in a series of other cases. 74 and 75, he distinguishes Barcelona Traction and Diallo. And then at page 921, I'm sorry, it's 922. Picking up in the 6th line, he says the contracting states confer enforceable rights against themselves on a category of persons defined as investors, which, dropping down to C, may assert rights under the bilateral investment treaty qua investor. So an investor which otherwise satisfies the treaty criteria may do so, just going back up to where the sentence starts, even if it holds the assets or property which constitute the investment indirectly. At 76, that's a paragraph that you saw yesterday with Mr. Wordsworth. And I won't take you through it again. It is certainly correct that applying the test in that paragraph to the case before him, Mr. Justice Butcher referred to control, but not, we say, as a necessary predicate to his conclusion. The relevant question in our submission is defined and answered in the first two sentences of paragraph 76 without reference to control, and the following part of 76 refers to control and proceeds on the basis that in that case it was only necessary to decide on facts involving control, but the analysis, we say, does not turn on control. It turns on whether, in accordance with the ordinary meaning and understanding of the word, the claimants were investors in the assets of the company, and whether the assets of the company can fairly be described as investments invested by those shareholders.
What do you see? I'm sorry.
Well, I was just to say, isn't a fair reading of paragraph 76 that the reason for the conclusion stated in the first two sentences is what is said in the rest of the paragraph?
Well, in this case, my lord, there are 6 members of the Dayani family. Mr. Wordsworth pointed out yesterday that we don't know that the award is not public, and we don't know from this judgment how those 6 individual investors owned and controlled the Singaporean company D and E. And in those circumstances, it's our submission that control can't have been determinative because we simply don't know how, as between those 6, the company was controlled. And it can't be, as a matter of analysis, that the fact that they brought the case together as 6 claimants is relevant to the question of whether or not any one of them had a protected investment.
Well, he's treating them together, isn't he? They brought the claim as a group, and he's treating them together. And he deals with it in paragraph 11 on the facts.
I certainly accept that he's dealing with them together.
And he says that they were the directing mind of the company. And what's more, DNA was a single-purpose company whose only asset was acquiring these rights and liabilities. I mean, what he seems to be saying is that you can have assets which are what he calls indirectly held or directly held. And this is just an intermediate, this is a classic intermediate holding company, isn't it? You just do it through a corporate vehicle. It would be the same thing if it was, I would think, if it was held on trust for the relevant investor.
I accept that those were the facts in this case. What I don't accept with respect, my lord, is that all 6 could be treated together because all 6 of them would have to, each of them would have to individually qualify as an investor with an investment under the treaty.
Are you able to show any case where the putative investor is a shareholder in a company, but either on its own or together with its associates does not own all the shares in the company?
There's one case in the bundle, it's called Kardasopoulos and Georgia, where that fact pattern exists, and I'll come to it, my lord. But before I do, I've heard what the court said about Dayani. Could I go to EIB in Slovakia first, and then go very briefly to Kardasopoulos? We can take EIB in Slovakia reasonably quickly because I'm conscious the court has been referred to it already. It's in volume 1. It's tab 12, page 132. If we pick up on page 139, at paragraph 294, Slovakia argued that a protected investment did not extend beyond assets directly owned by the foreign investor. to include assets directly owned by a local company in which the foreign investor had an interest. And on page 140, picking up at the end of the 7th line, Slovakia put it in these terms. Additionally, the term assets referred to in Article 1.1 means assets owned by that investor, not assets owned by someone else. Then at 296, Slovakia pointed to a provision in the treaty which expressly referenced assets owned by a company in which an investor owned shares as giving rise to the inference that other provisions which contained no such reference should not be so interpreted. Article 4.3 of that treaty was in substance equivalent to Article 7.3 of our treaty, and that's what you were referred to at the end of yesterday. The tribunal's analysis starts at page 146. The heading's just above 315, but then if we could pick it up at page 148, in 319, in the last two lines, the tribunal identified the issue as not what type of asset can constitute an investment, but rather what link is required between that asset and the investment. 320 conveniently summarises the relevant fact pattern, but Mr. Wordsworth described that yesterday, and so I won't go over it again. (321), if I could ask the tribunal to read that. At least to the end of the sentence, that is the first sentence finishing on page 149. And so the tribunal rejected the notion that only an asset directly owned by an investor could be an investment for the purposes of the arbitral clause, and again cited the broad treaty language, which turned on the verb invest. And it is again correct, as was emphasised yesterday, that in this paragraph the tribunal referred to the investor making an investment through a subsidiary, and here that EIC was a 100% owned subsidiary of the investor. But again, in our submission, the tribunal's language and analysis rested on the broad language of the treaty, and the fact pattern that the tribunal was concerned with was whether indirect investments, assets held by a company in which an investor in turn holds shares, could fall within the meaning of a treaty definition of investment, which turned on the verb invested and held that it could. And that, my lords, is consistent, if we look at 149 at paragraph 323, with the tribunal's treatment of Article 4.3 of that treaty, which, as you know, is similar to 7.3 of ours, and it's this paragraph 323 to which Mr. Dar took you right at the end of yesterday, and he was focusing on the very last sentence. But if I could pick up at the penultimate line on page 149 in para 323, what Article 4.3 does is to make clear that where the foreign investor owns not the factory itself, but a shareholding, even a very small one, in the local company which owns the factory, a company the majority of whose shares may well be owned by nationals of the expropriating state or other shareholders who could not qualify as investors under the BIT, and who would therefore have no entitlement to compensation under the agreement, adequate compensation must nevertheless be paid to the foreign investor. Now that last sentence is considering that, the last sentence of the paragraph, to which Mr. Dar took you, is considering that the assets of the company might be the investment of the shareholder. Mr. Dar sought to brush that aside on the basis that this was 100% indirect ownership case. The problem with that analysis is that it comes at the end of a paragraph that is explicit that this kind of provision applies even to small shareholders. And that follows through to 324, where the tribunal appears to regard the protected investment in this scenario as the factory, held indirectly through shareholdings that may be small. That's what we get from 323, and not, as Slovakia had argued, as only the shareholding itself. And it is, in my submission, therefore wrong for India to suggest that the analysis in this award is somehow limited to situations of control, at least in respect of the kind of scenario envisaged in what I might call for shorthand the paragraph 3 scenario, 7.3 in our treaty, 4.3 in this one.
That paragraph's dealing, isn't it, with the case where the person is an investor in the shares?
It is, my lord.
It's not saying the factory is the investment.
No. It's dealing with a clause like the one in our case, where the investor has an investment in the shares, but the factory is taken.
That's correct.
So it doesn't tell you anything about whether the factory can be treated as an investment of the shareholder.
In my submission, my lords, paragraph 324 is treating the factory as an investment of the shareholder. It says in the sentence beginning and taking up most of the fourth line, since the respondent's interpretation of Article 4.3 is that it provides for a duty to compensate notwithstanding that there is no such investment, it would follow that a dispute regarding the arrangements for payment of compensation under Article 4.3 would not be subject to arbitration. So the tribunal is rejecting the idea that the 4.3, that the factory can't be treated as an investment, and in this paragraph 324, treating it in that way. I accept that there's a certain degree of elision occurring, as fell from my Lord Justice Males yesterday, but in our submission, that's what's happening in 324. And when read with 323, this case, we say, does not turn on control, although it certainly existed on the facts.
But this was all in the context of the case about 100%. So the respondent's argument was that even in the case of 100%, you couldn't have the indirect investment, and they're dealing with the respondent's argument. It doesn't tell you anything about a case of minority shareholding.
I accept that this case is not authority for the proposition that a minority shareholding can lead to this result. I accept that. Our submission is that the analysis does not rest on it being a 100% control case.
But it wouldn't be authority anyway, would it? It's an award.
I entirely accept that too. It's the award that Mr. Wordsworth was keen, in respect of which he was keen to emphasise the eminence of the chair of the tribunal, but I take no point on that. Its analysis is either
It's an award
or
in
it's
relation
not.
to a different treaty.
I accept that too, my lord. But that's true for all of the awards. Could we now go to EDF and Argentina? It's in volume 1. It's at tab 8. It starts on page 77. This is a decision of an ICSID annulment committee upholding the award of a tribunal. If we pick up on page 84, at paragraph 19, a consortium company called Sodemsa was incorporated in Argentina. The 3 claimants each held a minority interest in that company. It's EDFI at 45%, SAURI at 15%, and Leon at 40% through yet another intermediate holding company. Sodemsa in turn acquired 51% of the shares in another Argentine company called EDEMSA, and EDEMSA was party to a concession agreement with the government of Mendoza. The contract in that case was thus a step further away from the claimant investors than the BSA is in our case. If we then go to page 87, at paragraph 28, this records the tribunal rejecting the argument about Barcelona Traction and Diallo. And then the last line of the part of the paragraph before the quote on page 87 records the tribunal's essential finding: the treaties were broad enough to cover indirect investments. And then in paragraph 174, if I could ask the court to read that, and 175, that's the quote from the tribunal. That's the award that was upheld. The analysis of the annulment committee begins at page 91. And then picking it up at page 94, at paragraph 255, the ad hoc committee agrees with the tribunal's essential finding. And this is in circumstances.
Sorry, which paragraph have you gone on to now?
255, at the top of page 94. The ad hoc committee agrees with the tribunal's essential finding, and this is in circumstances where each claimant has a minority stake in Sodemsa, which is the consortium company, which in turn holds 51% of the shares in EDEMSA, which in turn is party to the concession contract. 256 and 257 are the paragraphs dealing with Barcelona Traction that Mr. Justice Butcher cites and Dayani. The last paragraph to which I would draw the court's attention is on page 96. It's 261. Argentina had suggested that there was contradictory reasoning in the award, and in particular that the tribunal had wrongly suggested that the claimants were party to the concession contract. And picking up at the end of the third line, the annulment committee notes that the award was describing what the tribunal considered to be the underlying economic reality, namely that the claimants had invested in the concession. And then the next sentence adds that it was not dealing with the issue of who was a party to the contract in the strict sense. My lords, the three propositions that we seek to draw from these cases are first, that there's no barrier in principle to the rights of a company in which an investor holds shares being treated as part of the investor's investment. Investment companies, investment treaties can and do protect investments made by an investor through another company in which it holds shares. The second is that whether any given treaty will do so is a matter which depends on the correct interpretation of that treaty as the lex specialis, and then the application of that to the relevant facts. A majority interest or a controlling interest is required by some treaties, like the treaty in Azurix and Argentina, to which India has referred, but it is not required as a matter of principle. The question, in this case, is just whether the BSA was an asset invested by RAKIA. The answer to that does not depend on whether RAKIA was a party to the BSA or whether it was a majority or controlling shareholder of ANRAK as the party to the BSA. To use the expression from EDF, it just depends on the economic reality. And the third proposition is simply that rules and cases relating to corporate personality or privity of contract, or when look-throughs might be acceptable, in the different contexts of domestic legal systems and diplomatic protection under custom, do not assist in interpreting investment treaties. India's reference to the fact that RAKIA is not, as a matter of Indian law, the owner of ANRAK's assets or a contractual party to the BSA is therefore not the point. And India's references to Swissborough, that's the Lesotho case to which you were referred yesterday, or Professor Douglas's treatise, or to the extract from Mr. Landau's submissions before the judge, in this case, are therefore all in our submission beside the point. The treaty doesn't require ownership or privity. That brings us, my lords, further to India's attempt to distinguish those cases. I said this would be the second part of my legal submissions. And the first is the control theory. And it's certainly true that some of the cases do mention control, and in some cases that's because the treaty requires it. Control may be present on the facts, And I entirely accept, my lords, that if control is present, it's more likely that the relevant treaty criteria are satisfied. Our submission is that control is not the only way in which the treaty criteria may be satisfied. And that another basis may be circumstances, like these ones, where the company was a special purpose vehicle, incorporated and capitalised to carry out a specific investment project, of which the relevant contract was an essential part. And just as a matter of ordinary meaning, making an investment or investing does not require control unless the treaty says so. And we can test that with hypotheticals. And all else equal, the question is why a 49% shareholder would be in a different position to a 51% shareholder, so far as whether they had a protected investment was concerned, and where any distinction of that kind would be found on the treaty language applicable in this case. And that question might arise where a foreign shareholder has a minority stake for purely commercial reasons, but it also might arise in circumstances where, by reason of regulation or just political fact, a foreign investor in a particular industry or project will simply only ever be able to be a minority participant. 51% or 100%, as well as not being necessary, also may not be sufficient. If we imagine the day trader, if the day trader had a big day and bought 51% or even 100% of a company, it still wouldn't make it an investment. Or a case of dilution. If RAKIA had started at 51 and been diluted to below 51, on these facts we say that wouldn't make a difference. Or if it had started at 100 and been diluted below 50, we say that on these facts control wouldn't be a factor that would cause RAKIA to have made an investment but then no longer have an investment because of that dilution. And then there's the situation of multiple minority shareholders. In EDF, the court saw that it was 45, 15 and 40. And again, they need to be treated individually for the purposes of whether each of them is an investor with an investment. As to the empirical point made against us, and I'm conscious of the question that my Lord Justice Miles posed to me about that empirical point. First of all, we say with respect that as an empirical point, it's not of analytical value. Secondly, we say that EDF is such a case for the reasons that we've described, and that there's no analytical significance to claimants claiming together in one process when asking the legal question of whether each of them is an investment protected by the treaty. And there are two cases to which I'd give the court reference. One of them I mentioned is Kardasopoulos and Georgia. The relevant passage is in the full authorities bundle, which you only have in electronic form. It's a short paragraph. I'll just read it out for you. The reference is page 2340 in that unabridged bundle. It's paragraph 141, where it said, the tribunal therefore concludes that claimant had an interest in Tramex Panama at the time the JVA was executed. The tribunal accordingly finds that claimant was, at all relevant times and remains now, the beneficial holder of 50% of the share capital in Tramex Panama and indirectly owned a 25% interest in the joint venture vehicle GTI, which carried out an investment in Georgia. That's paragraph 141 of the decision on jurisdiction. The merits award did not make it into the bundle, but what was expropriated were the assets of the joint venture vehicle GTI, in which the 25% interest was held. And if my learned friends wish to check that in the merits award, it's paragraphs 155 to 158 and at 387. There's another case in the unabridged bundle which responds to the question that's been put to us in terms of minority shareholders. It's the case of Skubensko and Macedonia, and the references are pages 3117, 3169, 3149 to 3150, 3170 and 3183.
I thought the idea of authorities bundles was that the cases which were going to be referred to in court would be provided to us.
Except for Kardasopoulos on the merits, the other two to which I referred are in the authorities bundle, and it's only occurred to us to refer to those particular passages in circumstances where the empirical point's been emphasised yesterday and today, that there isn't a specific case. So I apologise for the inconvenience, my lord. The last point I'd make about India's approach arises from the reliance on Article 1.8. India says that Article 1.8 and 10.2 somehow mean that the definition of investment in Article 1.1 should be narrowly construed and should exclude indirectly held assets. That, with respect, is circular. In requiring action to be applied directly to an investment so as to constitute a measure, Article 1.8 says nothing about what constitutes an investment. An investment consists of one or more assets which must be invested by an investor. That's the Article 1.1 question. The requirement in 1.8 that action must be applied directly to such an investment says nothing about which assets have been invested by an investor. My lords, I can be brief on the third part on the application to this case. RAKIA says that its investment extended to the BSA in circumstances where this definition of investment applies to these particular facts, and that what is not determinative is that RAKIA is not a party or that it held a minority stake. That's because Article 1.1 embraces every kind of asset, and the non-exhaustive list which follows includes rights or claims to money or to any performance under contract having financial or economic value, without specification as to the parties to such a contract, and the link, to use the word that we saw in the cases, between every kind of asset and the investor is invested by. And that's in the context of Article 3.2, encouraging the incorporation of local companies to carry out investments. We say that the core factors on the facts are the central component of the project being the long-term exclusive supply and purchase of bauxite from the Geraldine mines for use in the refinery and smelter. And that although RAKIA was the minority partner, it had negative control over the purpose of the company, and that the BSA to which ANRAK was then party...
It didn't have control over the business of the company, did it?
I accept that, my lord. The BSA to which ANRAK was then party embodied the central component of the project in which RAKIA was choosing to invest. Those, my lord, are the submissions of RAKIA on Respondent's Notice, ground 1. I'm in your lordship's hands as to whether you wish me now to make the application for permission on Respondent's Notice, ground 3.
Yes, well, that's the next point to arise, isn't it?
I've been handed transcript references in response to the question posed to me by my Lord Justice Phillips on the transcript, and the pages are 57 line 24 to 58 line 9, and page 59 line 14 to page 60 line 6. I don't propose to make any further submission on that. My lords, the ground subject of this application is pleaded in the Respondent's Notice at paragraphs 6 and 7. It is that it's a core bundle 5, pages 54 to 55, core bundle tab 5. It is that the standing offer to arbitrate is in Article 10.5 of the treaty read with Article 10.4, and it is not conditional on Article 10.2 or 10.3, which instead deal with attribution of conduct to the state, not a tribunal's jurisdiction over a claim against the state. RAKIA abandoned this point shortly before the hearing before Mr. Justice Knowles. It's therefore a new argument on appeal, for which we have always accepted that permission is needed, and we deal with that in the Respondent's Notice on page 55 at paragraph 11. We are conscious that the principles on granting permission are well known to the court, and it might be most efficient just to go to tab 40 of the authorities bundle at page 799.
Is this Notting Hill and that line of cases?
This is Hudson and Hathaway, but it picks up Singh and Das and it summarises Notting Hill. So your lordships can see at page 799 where Lord Justice Lewison quotes at paragraph 34 paragraphs 16 to 18 at Singh and Das, and then on the next page at 35, he summarises Notting Hill Finance. Now, India rightly acknowledged that the reference in Hudson at 36 to the potential distinction between a respondent taking a new point and an appellant taking a new point. That's in India's supplemental skeleton at paragraph 17. If there's a difference, our submission is that the court should be more willing to permit a new argument to be run by a respondent for the reasons intimated by Lord Justice Lewison at paragraph 36 in Hudson and Hathaway. That's on the basis that CPR Rule 52.13 permits respondents' notice grounds seeking to uphold the decision of the lower court for reasons different from or additional to those given by the lower court, which on their face would allow new arguments to be run as much as those run and rejected below. Of course, the respondent already has the benefit of the lower court judgment, and so permitting it to run a new argument seeking to uphold that judgment is not as prejudicial as permitting an appellant to seek to deprive the respondent of a judgment in its favour by reference to a new argument. So it may be relevant.
Why does that work? Because if the respondent's notice point is only relevant if the appeal succeeds, in which case they've won. So it is prejudicial to them.
Well, we certainly don't say we have free rein, but it would only work in circumstances where we already have a judgment in our favour, and it's sometimes said that if there's a judgment in the appellant's favour, that's a reason not to allow a new argument. It's as high as I put it. We certainly put our case, my lord, on the Singh and Das principles on their terms. Really all I was doing was drawing the court's attention to what Lord Justice Lewison says in paragraph 36.
Are you going to give us an explanation of why it wasn't run below?
My lord, one of the points I'll make is that that's not a relevant factor. One of the reasons...
So the answer to the question is no, then?
I am not, my lord, going to provide an explanation.
Well, why should we, in that case, indulge you in just simply changing your mind?
My lord, the reason, we say, is that the Singh and Das principles are as they are, and I propose to make short points on their application, and that motive is not one of them. But we accept that it's a change of mind case. And so if the court's position is you can't change your mind, then I accept we don't get permission. Our submission is that that's not one of the relevant factors.
Was it relevant, a further factor, that by and large this court doesn't even entertain arguments from below without permission from the judge?
We say that doesn't apply in this case because the relevant counterfactual is that we still won below and had run this argument but had not succeeded on this argument. And in that scenario, India would still have needed to apply for permission to appeal, and we would have been entitled to have run this point.
No, sorry, that misses the point. The point is that the principle underlying the Arbitration Act is that these are matters which are to be dealt with by the first instance judge. And it's only in exceptional circumstances that they, with leave of the judge, that it comes to this court. And it's a intense flouting of that principle to invite us to deal with a point that you not only didn't argue below, but chose specifically not to argue below. So whilst it may not technically require permission, do we not to take into account the fact that this is an argument which the commercial court judge didn't even have the opportunity to express his view on? And he is the primary decider of issues in an arbitration application.
My Lord, my answer to that is in two parts. First, that we wouldn't have needed permission for the reason that I explained. And secondly, because we didn't need permission, the factors that are specifically relevant under Section 67 and it being an arbitration case don't apply because we wouldn't have needed permission anyway.
But we don't even have the benefit of the judge's views on this point.
That's correct, my Lord. You have...
That there's a coach and horses through the Arbitration Act, isn't it?
You have the benefit of the arbitrator's views, but not the judge's. I accept that. So if the court is willing to entertain my submissions on why we say the Singh and Das principles apply specifically to this case in short form, then I'm ready to make those now.
All right. Well, complete what you want to say on the application for permission. I mean, essentially, you've said it, haven't you, in your respondent's notice?
Yes, but I don't propose to take very long, my Lord, but
right.
I do have more to say than what's in
Anyway,
the
your position on the Arbitration Act is that, is this right, that even if you had taken the point below and lost on it, and you'd won, as it were, on Mr. Otti's points, you would not have needed the judge's permission, is that right,
It is,
to raise it on a respondent's notice in this court?
That's our point, my Lord.
Yes, I see.
But if Mr. Otti's points, if I can call them that, hadn't succeeded, and this was the only point on which you had... Oh, I see. You still have won. Okay, so you'd taken this point and lost everything. You would have needed permission to raise this point.
I accept that. But that's not our case. First, it's a pure point of law. Secondly, it does not require or involve new evidence. Thirdly, it would not have resulted in the trial being conducted differently with regards to the evidence at trial. And we know that because the point was pleaded in RAKIA's arbitration claim form. It's ground 2 and in particular 2.2. That's at tab 12, page 132 of the core bundle. It was canvassed in the witness statements adduced below. It's in Bradfield 1, supplementary bundle page 58 at 20.1, and then she identifies it at 62 to 69 as a matter of full and frank disclosure, and then says at para 66 that it's primarily a matter of submission and beyond the scope of the witness statement, and that's matched by Mr. Langley for India at page 128, paragraph 34, where he also rightly describes the interpretation of Article 10 as legal argument and not a matter of evidence. So if it had been run below, so far as evidence is concerned, the hearing would have been conducted in the same way, without live evidence, as is usual for Section 67 hearings. The fourth point is that the point of law that RAKIA wishes to raise is dispositive, if RAKIA is right about it. The fifth is that India has had adequate time to deal with it in writing, was identified in the respondent's notice, argued in the skeleton, and India has replied to it in the supplemental skeleton. It was run by RAKIA in the arbitration, and so India has dealt with it not only in writing before this court, but in full before the arbitration. The sixth point is that there's adequate time to deal with it at this hearing. The seventh is that there's no question of India having acted to its detriment on the faith of the earlier omission. And the eighth is that India can be protected in costs if needs be. And that, my lords, is the basis for which we say that all things considered, the overall course of justice militates towards allowing RAKIA to raise this point.
India say that you do need to refer to new material because you want to look at translations.
My Lord, there was an application in on translations, and there are 3 paragraphs in our skeleton
I think you've abandoned that, haven't you?
that refer to them, and we have abandoned those so as there's no need to pursue the translation application. There's no need to burden the court with the rights and wrongs of why that's happened, but the position before you is that there's no translations application, and we don't rely on those 3 paragraphs.
So just to be clear on that point, when we read Article 10.2, that says, in the context of the Republic of India, this article shall cover measures, etc. And you want to run the argument on the basis that we use that text.
My Lord, we do.
Yes. All right. Well, we're going to rise for a few minutes.
Court rises equal.
So, yes, it was.
Court rises, people.
We will hear from the appellants on whether the respondent should have permission to raise this point, and then see where we go.
I'm grateful, my lords. I believe the court already has the key point, which is that this is an arbitration claim where the underlying policy is one of speedy finality. And if RAKIA were to be given permission now to advance this point by way of Section 67 challenge to part of the award, that would be the first time in which this is being argued about before an English court almost 4 years to the day after the award was issued. The decision to drop the point was plainly a decision which was reached after careful consideration by a highly experienced counsel team. There's been no positive evidence offered for why it was dropped, but in my respectful submission, one can infer that in addition to reflecting a view on the merits of the point, that was a decision taken to procure tactical advantage below by enabling the hearing time below to be focused on the one point on which the respondent really wished to win. And in my submission, it would be unfair for that decision, especially when no evidence is offered as to why the decision is being changed.
You mean because there was, what, a fixed time for the
Yes,
hearing
it was
below,
fixed for
and
2
there wouldn't
days.
have been time to cover this point as well?
Yes, in my submission, it was listed for 2 days, and so a decision was taken to drop this point to enable more time to be spent on the point that Mr. Landau dedicated more than a day of argument to.
And if they had run this point and lost on it, or even if they had run this point and the judge had said, because I'm in their favour anyway, I don't need to deal with it, do you accept that they would be entitled to raise it by way of a respondent's notice in this court without permission, or would they need some kind of permission, and if so, why?
I don't accept that, for it depends on what happened below. If they had won on the point on which they won, and had argued and lost on the point that they're now seeking to run, India would have been entitled to ask for a declaration from the court on the proper interpretation of Article 10.2, and to the extent that it's relevant, certainly in my experience in other treaty cases, declarations are frequently granted as to the proper interpretation of a treaty provision when there has been dispute about that following a trial. So if they had won on the point on which they won and lost on the point on which they now seek to run, India could have sought a declaration, and if that had been granted, they would have needed permission from the court below to appeal against that.
Because the order would have been different.
Exactly. So A, India is prejudiced because in that situation it would have been able to resist the grant of permission to appeal. B, if an application for permission to appeal had had to be made to the first instance court, India could have sought for that grant of permission to be conditioned. So by way of background, RAKIA provided security of costs for costs when it initially brought this claim, which was returned to it after it won. If it had been seeking permission to appeal, India would have been able to say that grant of permission should itself be contingent on security, as indeed RAKIA said to India when India sought permission.
But I can see that in a counterfactual world where it had been argued, there might have been a different order and therefore they would have needed permission from the judge. But we're not in that, not being in that counterfactual world. It is raised as a respondent's notice point, so they don't need permission.
No, I cannot say that they need permission. No, what they need permission to do is from you is to run the point.
Yes.
And in my submission, it's not purely a question of simply running a new point on appeal. One should also take into consideration the fact that it was dropped below. So it is a requirement for permission to withdraw a concession which was made below, not simply running a new point
But
the
we
first
do
time on appeal.
not infrequently allow concessions to be withdrawn.
Yes, and I accept that. And the overall test is it just? Picking up on the points that Mr. Juratovic made by reference to the authorities, he took the court to Hudson and Hathaway. I don't propose to go back to it, but just to pull out the key points which India relies on in it. First, that the court should be cautious about allowing a point to be raised for the first time on appeal. I obviously accept that there are a spectrum of cases, some cases in which it would have changed the presentation of matters below, in some cases where it's a pure point of law, and I accept that this is at the pure point of law side of that spectrum. But that is not determinative, because even in that situation, as is made clear at the end of paragraph 35 in Hudson and Hathaway, one has to consider the nature of the proceedings and any prejudice to the opposing party if the new point is now to be taken. And the overall question is it just? As to the nature of the proceedings, the court has the point, obviously, that it's an arbitration claim. The overriding principle in the resolution of arbitration claims is one of speedy finality, and that is to promote certainty. And in my submission, it's wholly inconsistent with that to allow a challenge, in effect, to be brought for the first time 4 years after the award is issued. At a more granular level, if I could put it that way, there are...
Is that a point which has greater weight, do you say, when the new point is one which is challenging the arbitrator's decision rather than seeking to support it?
Yes, in my submission, for it is a challenge to an award. At a more granular level, obviously the court will have well on board that there are exceptionally tight time limits for bringing arbitral challenges, which is what this is. It would have to have been brought within 28 days. Obviously it was brought within 28 days, but then it was dropped. In my submission, if below it had been suggested that having dropped it, it could be brought back to life, the answer to that would obviously have been no. And in my submission, there's no reason why a different outcome should follow on appeal, especially given the points which are already made in interactions with the court about the fact that had it been run below on various permutations, RAKIA would have needed permission from the judge, and India would have been entitled to oppose that. And then my final point is the obvious one, that in my submission is highly unsatisfactory, that the court would be being asked to look at it without the first instance court already having done that. I mean, the arbitration regime, or the regime under the Act, is put in place for very good reasons, which is to allow a first tier review of an award, and then to have control at that first instance level of whether matters go further. And whilst I completely take on board the points about being able to take points by way of respondent's notice, this is fundamentally a challenge to the award, and the approach of RAKIA is to deprive the first instance court of the ability to have looked at that and decided it, and therefore to deprive A, this court of the benefit of that process, and B, deprive India of the ability to have opposed permission to appeal from the first instance judge. The overriding point, though, in my respectful submission, is that if the test is one of justice, then that is what one gets out of Hudson and Hathaway. No positive reason is being put forward by RAKIA for why it is just to allow them to behave in this way. If the court wanted to consider the merits at a very high level, India's position obviously is that this argument has no realistic prospect of success.
Well, we haven't really asked Mr. Juratovic to deal with the merits. We're just on permission at the moment.
No, but there are the reasoning of the tribunal is set out in 5 very concisely reasoned pages. There are points in there, in particular, about how this deprives the limitation clause of any effect and how it would not make any sense for RAKIA's interpretation to be right, given the presence of the carve-out in the MFN provision.
Might be talking us into it now.
Yeah, those points are completely blanked in the skeleton. That's because there's no response to them in my submission.
All right. Right. Well, thank you very much. Without going into the merits, do you want to say anything in reply on permission?
Thank you, my lord. Nothing in reply.
We'll rise and come back in a while. See if we can decide this. At this stage, we may or may not be able to do so.
Court rise if able.
May want to up the volume, I don't know. Court rise if able.
going to refuse permission for this point to be run. We'll give the reasons in the judgment. So I take it that then concludes the submissions from the respondents.
It does, my lord. Thank you very much.
Very good. Thank you. Yes. Yes. Thank you, Mr. Webster.
Sorry, my lord.
Right. Now, how long do you think you're going to need for your reply?
My lord, I think longer than we have today, which is not an answer to your question. I do note that. I would estimate approximately 1 hour.
Right. Really? All right. Well, let's make a start.
Well, I'm grateful.
We'll take stock at 4:30.
It may well be that things move faster, my lord. I will endeavour to do so.
And if we need to come back on Thursday, if you can't make the points you need to make, then we must do so, of course. But let's see how we go.
I appreciate how unpopular that will be, and therefore I will do my best. My lord, the question for the court that my Lord Justice Phillips posed was whether a binding action, I can summarise, towards the business or project meant that there is a direct application to the shareholders in that business. Essentially raising the question of what is the proper construction of the term measure in this treaty. And that involves a question of what is the test that RAKIA says is the correct construction of applied directly to an investment. That question depends on the proper interpretation of the treaty, of course, and cannot turn on the facts of an individual case. Cannot depend, we say, on how the investment happened to be held at the time of the alleged measure, point I'll come on to. There are two candidates before the court and that are proposed by RAKIA. The first candidate is the targeted at test, which was the analysis adopted by the judge. And the second approach, the second candidate, is what I'd call the impact on value test. And those are the only two candidates that the court has before it. I understand my learned friend's analysis of direct nexus to effectively be the same thing as impact on value. So those are the two routes being offered to the court as a rationalisation of how GOM 44 was applied directly to RAKIA's shares. And in our respectful submission, neither works. I can start with the targeted at formulation, which was what found favour below. Applied directly to meaning targeted at the investment. Your lordships will note that my learned friend did not actually positively advocate that as the correct construction of the treaty. My Lord Justice Mayles pointed him to the relevant paragraphs of Mr. Justice Knowles's analysis of the different candidates targeted at, collateral effect, and so on, and asked him what his position was on those. It wasn't actually clear when one goes back to the transcript. I think where my learned friend came out at was that it was sufficient that it was targeted at the project or investment, but not necessary. That's different to the position adopted below by the judge. In the judge's analysis, it was necessary for the binding action to be targeted at the investment, and that's an important point, because obviously on the judge's analysis with respect, at paragraph 111 and 112, his conclusion was that a measure meant, or they applied directly to wording meant, targeted at. So it's not actually clear my lords, that RAKIA supports the analysis of the judge as to the proper construction of the treaty. The question, obviously, for the court is it the right construction of the treaty? And in our submission, plainly not, to say that the words applied directly to mean targeted at. And you'll have had my submissions yesterday on that.
I think the phrase that was used was targeted at or directed at.
Yes, my lord. In our submission, there is no difference, I can say, between targeted at or directed at. They are treated by, certainly, Mr. Justice Knowles, as synonyms, effectively. And I didn't understand my learned friend to be suggesting that there was going to be any daylight between the two tests. Daylight in the sense of between the words targeted at and directed at. The question, obviously, is if one can get that targeting test out of the applied directly to language. And in our submission, just on the ordinary meaning of those words, one plainly can't get that. What the applied directly to an investment test requires is not simply that it's targeted at an investment, but that it reaches the target. The binding action is directly applied to it.
Paragraph 112 is saying it's sufficient and not necessarily necessary, because it says the test is satisfied where there is targeting. It may be different with measures of wider general application, but it may not. So that is a sufficient point, isn't it?
My lord, I think the difficulty with the judgment, I may say with respect, is when one looks, I think it's at paragraph 1112, you're right to say it's unclear, but actually at 113, the judge says that the result is a balance. So it's quite clear, I think, what the judge considers the result to be. He's opposing at 112, measures are applied directly to an investment where they are targeted at the investment. The position may be different with measures of wider application. At 113, the result is a balance. So that seems to be the result of his interpretation of the treaty. And one can see that again at 115, when he refers to the working of these provisions is not affected by an appreciation that to be a measure as defined, an action will be targeted. It's a penultimate line, that is directed. Yes. So in our submission, on a fair reading of the judgment, Mr. Justice Knowles was saying that it was necessary to find that the binding action was targeted at the investment. And the difficulty with that, as we say, is that it doesn't find support in the terms of the treaty, which instead requires something quite different. Now, as I say, my learned friend didn't focus on how one can get, as a matter of ordinary language, that test out of Article 1.8. He instead focused on one or two contextual points in the treaty. One of them was a point that I made yesterday regarding clause 14.2, which he said didn't assist our case. And as your lordships will appreciate, clause 14.2 we discussed yesterday, but the short points, page 152 of the core bundle. Nothing in this agreement precludes the host contracting party from taking necessary reasonable measures in accordance with its laws applied generally on a non-discriminatory basis in circumstances of extreme emergency for the specific purposes of prevention of diseases or pests. In our submission, it's quite clear that what that is referring to is not that there are simply laws that are applied generally on a non-discriminatory basis. The application it's looking at is through the measure, because there are two conditions to access this liability defence. One is that you've taken a measure in a way which is applied generally on a non-discriminatory basis, and secondly, that it's in circumstances of extreme emergency. So that's what you say is the correct reading. And if that's our submission, and if that...
Forgive me, that can't be right, can it? Because a measure is by definition applied directly. So the reference to applied generally can't be to the measure, because we know the measure is being applied directly.
Well, my lord, it can with respect, because if one imagines a situation of extreme emergency, say a COVID type regulation, to use the context of this clause, it may be applied directly to a number of investments that require, one imagines, COVID's probably a bad example, but factories or hospitals, so applied directly in that sense to those assets. The question is that direct application being done on a, is it being done on a non-discriminatory basis? It'll be applied, the clause assumes that it will be applied generally. So if one takes, as I say, a nationwide COVID regulation that applies to every hospital in India, that is what it's contemplating, that sort of thing. So it's that the measure, in accordance with its laws, is applied generally on a non-discriminatory basis.
Doesn't it mean if you're doing it generally, for instance, your COVID analysis, you're doing it all over the country, the fact that you're applying it directly to this business isn't precluded?
It isn't precluded in the sense that, so first stage it would be a measure, because it'd be applied directly to that investment. So let's say a foreign hospital owned by a foreign investor, it would be applied directly. It's not precluded in the sense that there is a recognition that on the merits there is a defence, or it's out with the scope of liability under the treaty, because it says nothing precludes the host state from doing that. So it'd be permitted.
Or there may be laws of general application which give the government the power to shut down premises for health reasons, but the government decides that it will shut down this particular factory because there has been an outbreak in this area, but not the rest of the country or the rest of the province.
Precisely, my lord, and in that situation...
And that would be a measure applied directly to this factory, and there would be an opportunity to arbitrate on the basis that the health reasons given were spurious, for example.
Yes, and going one step further, the exception to liability in 14.2 would then not apply, because it would be on the hypothesis your lordship is putting, a discriminatory measure. You're going after a particular foreign investor in that example, say. So the only point we're seeking to draw from this provision is that the draftsman and the parties contemplated that one could have a capital M measure that is applied generally. And that makes it difficult on the judge's analysis, which says it's all about targeting at a particular investment.
But it's a lot. That's a lot of weight to put on what is in its terms for avoidance of doubt provision, isn't it? Nothing in this agreement precludes. It's saying, look, well, we're all very familiar with such provisions in contracts or in legislation. It's just to clarify that nobody should be under any misunderstanding that nothing above here stops this important action, which is to prevent disease or pests.
Yeah, I fully appreciate that we are placing weight on it. I would, with respect, suggest it's not a lot of weight, because the significant point, as we say, is what it is contemplating a measure can be doing. But there are other pointers within the text of the treaty, my lord, which support this. It's not purely an Article 14.2 point. And if I can just draw your attention to two others, we don't need to go through them. Article 7.4, made this point yesterday, refers to regulatory measures. Short point, I'm not placing enormous weight on, but it is again a signpost that it doesn't have to be targeted at a particular project. A provision I do also wish to draw to your attention, please, is in Article 4, and that's at page 141 and 142. If I could ask you to turn to that, please. My Lords, so that refers to investments by investors shall enjoy full protection and security, so on. It's the second sentence which I'm particularly interested in. Neither contracting party shall in any way impair by arbitrary or discriminatory measures the management, maintenance, use, enjoyment or disposal of investments. And we say that the judge's analysis of targeted at doesn't sit comfortably with this concept of discriminatory measures. This is a very wide-ranging prohibition, substantive prohibition in the treaty under 4.1. And the important point is that the fact that the parties have specifically provided there for that prohibition suggests that the definition of measure was not itself intended to distinguish between cases of targeted at action and cases of wider general application. If the measure was targeted in the way that, on the hypothesis, for example, that my Lord, Lord Justice Mayles put to me, that would be an example of a discriminatory measure which would attract liability under 4.1. So cases of singling out of a particular project are dealt with by 4.1. They're not baked into the definition under 1.8.
Isn't it fair to say, though, that throughout this treaty, it's not exactly a model of consistency and precision? So picking up the odd references here and there and saying, well, that all demonstrates what 1.8 means, I think is a bit difficult. I mean, the best example being in 7.1, where it talks about direct or indirect measures. So
my Lord,
we've got a concept of indirect measures being applied directly.
My Lord, I can't dispute that, and that is to some extent why we're all here, in terms of the difficulties of finding a coherent scheme for this document. And the tribunal noted the very point that your lordships just put on the difficulty of direct or indirect measures.
But what at the end of the day is the key point is your interpretation of 1.8 is such that it only protects an investment, a substantial investment in a business, which was originally by way of investing a lot of money, if there are measures which directly affect the shareholder. And that, at the end of the day, is the real difficulty in your analysis, isn't it?
Well, my Lord,
that doesn't provide the protection, doesn't protect the investment in the way that one would expect.
But with respect, the reason, and sort of, Mr. Otti had perhaps a fair pot shot at my so what point, but that wasn't meant to be a flippant comment at all. The reason why I would, with respect, dispute that it's a difficulty on our interpretation is because this is not, as we said yesterday, like the other treaties that one sees on a regular basis.
Well, I'm not sure you made that good, with respect.
No, well, clearly,
and at the end of the day, we have to read the words in the context of primarily the treaty.
Absolutely, my Lord.
Which provides lots and lots of provisions about encouraging investments, protecting investments, treating investments, compensation for damage or loss, expropriation, but most of that, in your case, isn't arbitrable.
Well, that depends on whether there is a capital M measure, my Lord. And so,
of course it does.
Yeah, and so
that's what we're arguing about.
Absolutely, but sorry to state the obvious point, but that is where really at the heart of it now, 10.2 and the limited offer to arbitrate. I call it limited. That's not a sort of jury point, or that is the reality that the court now faces, is that it is limited. Yes. Under 10.2 to executive measures.
Yes.
And that is not a sideswipe point. That is absolutely fundamental to how this treaty operates. For the very reason, my Lord, you gave, it absolutely does have lots of nice protections, treat investments fairly and equitably. But those, and it is, I appreciate from perhaps, I wouldn't call it a normal perspective, but from a private law perspective, it is odd that one would have rights granted in one document without a correlative remedy. Absolutely. But that is not odd within the scheme of this treaty. And it's not odd, and it's intended because of this insertion of measure. And I'm not putting, this is not about...
Well, an awful lot, on the respondent's reading, an awful lot of the breaches of these articles would be by way of actions of the governments, which would be measures and would be arbitrable. But you are seeking to further restrict the arbitrability by defining in measure so narrowly that it even removes that potential way of protecting or enforcing these protections by saying effectively that you can't even say that actions of the government are measures which fall within 10.2 unless they are, as you say, specifically directed to the form of the investment, not just the investment, it's in a broader sense.
Yes, and the reason we say that is because, as you say, the way my learned friend puts it is that his conception captures as a measure a form of binding action that impacts on the value of his investment. And we understand that case. That case, with respect, can't be built out of the wording that was chosen by the parties in 1.8. Maybe the case that gives better protection to investments, it may be the case, as my lord has identified, which would make each of Article 4, 5, 3, so on, have real teeth. I accept that. That's not what the parties chose. And with respect, we say that's a deliberate choice, because when one looks at where in the treaty they deal with impact on value of an investment, they do that expressly. We referred to 7.4 and 10.8 yesterday. And those are provisions which do deal with measure as a concept and then distinguish that from the effect of the measure on the value of the investment. So it's clear to the parties at the time of agreeing this that the concept of a measure is something different. It doesn't require baked in, does it have an impact on the value of the investment? And my learned friend doesn't explain with respect how one gets that out of Article 1.8, his case on effect. Instead, the question is put by reference, understandably so perhaps, to the facts generally of the case. And the argument that's made against us is, well, on the facts of this particular case, given everything that had happened, which I would like, with your indulgence, to come to, but given everything that happened, this must have been a measure applied directly to an investment. That really won't do, we say, as a matter of the VCLT approach. The way it was put today at page 95 of the transcript was, and my learned friend said, as I've already submitted, the binding action in issue in this case was, we say, in context, only sensibly interpreted as applied directly to the value of RAKIA shareholding. And then he said, essentially there was an inevitable impact on the value of this particular shareholding, and that meant it was applied directly. When the court goes back to have a look at how that is framed with respect, that changes the test, that changes the words that are being used in 1.8, from a test of applied directly to an investment to applied directly to the value of the investment or affecting the investment. And that's not permissible under the Vienna Convention.
Now, how are you doing? It's 4:30. If we were to sit, say, for another 15 minutes, would you finish without us putting pressure on you, or do we need to come back on first?
My lord, could you give me one moment, please?
Yes.
That's okay, because I think
are we going to hear from Mr. Wordsworth as well, or is it just you, Mr. Dart?
that's partly what I want to just
All right.
bit of. My lord, I do appreciate that this won't make me very popular, but we would like a bit of extra time to deal with this. I don't think it will be done in 15 minutes.
No. All right. Well, we'll adjourn until Thursday morning then. We don't need to hear you on the BSA point that Mr. Juratovic.
Okay.
So that might or might not shorten things a little bit. But no, we don't want to put you under unfair pressure. The presence of all these people in court suggests that at least some people think it's an important case, so we must hear it properly. So we'll resume on Thursday morning at 10:30.
All right, able.